Hey everybody, welcome back to Guns and Gadgets, the premier source for Second Amendment news here on the YouTube and hopefully everywhere else. I want to say real quick, I apologize. You may hear really loud thunder in the distance here. The window's about 6 feet away. There it is. I don't know if you can hear it. We just had lightning strike a mile down the street, so let's roll with this. So first off, thank you each and every single time that you come here and watch stuff. It really, really means a lot to me, and just know that it doesn't go unnoticed. Thank you. Your support has always been paramount. And that's why I'm bringing you this notice, because it's not good. Yesterday we went over the Department of Justice and how the ATF published their new proposed rule for pistol braces. And I've been reading that document, and I really don't know how any pistol brace could be not deemed, or anything with a pistol brace could not be deemed an SBR by looking at that new worksheet. Literally, it's that vague. So keep that in mind. And I just wanted to tell you something else that the DOJ did yesterday, and they published model red flag legislation for the country. If you remember old sniffing Joe Biden, old Bobo himself, back on April 8th, in the Rose Garden, we covered that here, he gave the DOJ 30 days to come up with something related to the killing of the proliferation of ghost guns, and they came out with that. And then he gave them 60 days to come out with something to address, what do you call it, concealable assault weapons. And he came out with that yesterday at the 59-day mark. They came out with that. And they also came out with the model red flag legislation. And I'm going to put some stuff on screen here that I think you all need to know. If you live in a state that already has a red flag, I know I'm blowing smoke. But for those of you who don't, this is dangerous because of the way it's worded. And they even have a clause in here or a paragraph to tell each state how to get people tied up into the NICS system so that they become prohibited people for never committing a crime. So before I jump into this, I know a lot of people, just like I don't know anything about architecture, some people might not know about law and procedure, criminal procedure. In order to be stripped of your right, of any right, even if it's your right to freedom by being incarcerated, you have to be proven guilty beyond reasonable doubt. That's a key thing to remember. Proven guilty beyond reasonable doubt. Now, to be charged with something, that's different. That has to just be probable cause, meaning it's more likely than not, about 51%, that you have done what you're being accused of, and then it's up to the judges and your lawyers to hash that out. But that's the scale on the criminal procedure as far as being charged versus being convicted. Two different worlds. Now, what does red flag look to do? You should probably know that already. I already have a playlist of red flag stuff. I'll have it linked above. But I'm going to go to this little sheet that they have released, and I want to show you some key factors in here to show you just how easy it is, according to this, to make people prohibited. So this is the commentary for Extreme Risk Protection Order model legislation, like I said, and I'll rip through it. It says here that research has shown that states can save lives by authorizing courts to issue extreme risk protection orders that temporarily prevent a person in crisis from accessing firearms. Now I'm going to pause real quick and let you know that there are already laws in every single state where if a person is in crisis, they can be treated, or they can be taken against their will if they're in a really bad state, where they can be treated by professionals and help them take care of whatever issues are a problem at that time. Whatever's ailing them, they can work through that. And if they do it voluntarily, they typically don't get put into any systems or checklists or secret lists where they become prohibited and stuff like that, because they're looking to take care of their problems on their own. Red flag, not so much. Let's go back. This model legislation provides a framework for states to consider as they determine whether and how to craft laws allowing law enforcement, concerned family members, or others to seek these orders and to intervene before warning signs turn into tragedy. Now, I thoroughly believe that if somebody is in a situation where they're a gun owner and they think that they're going to do harm to themselves or others because of whatever they're going through, that there should be avenues to help them, and preferably avenues from within, from within the family structure, from within friends, or even groups like Hold My Guns or Walk the Talk America. Those groups are there to help gun owners, not to hurt gun owners. So those things are something to look at before red flags, but states don't want that. They want, ultimately, the federal government wants to strip you of your rights. The model draws on a significant number of similar laws adopted across the country. Orders of this nature may be sought in some jurisdictions, for example, by family members or others concerned that an individual who is suicidal or otherwise in crisis will use a firearm or seriously injure or kill himself or herself or another person. Now, this next part is the key part. This talks about the two different types of statutes and how one can make you a prohibited person where the other one won't. The model legislation is designed to identify the main features and varying specifics of existing extreme risk protection order statutes that have been adopted in a number of states. These existing statutes may be of two types: warrant statutes that authorize courts to issue orders permitting law enforcement to search for and seize the firearms of dangerous individuals. And I know right now everybody's saying, didn't the Supreme Court just rule against that? It was specific to the community caretaking exemption to the Fourth Amendment. That is around automobiles. The police in Rhode Island used that to seize somebody's guns, and that was deemed illegal and unconstitutional. It's only addressing that area, but that decision could very well be used to attack red flags. They just have to be challenged specifically that way. The second are order statutes that authorize courts to issue temporary orders prohibiting dangerous individuals from possessing or acquiring firearms. So one is a warrant, the other is a judge's order. The warrant statute provides an immediate basis for law enforcement to seek court orders temporarily preventing individuals in crisis from accessing or possessing guns. However, standing alone, is that thunder? I gotta roll with it, guys, because I'll be editing it out all day long. We've got some nasty storms here. However, standing alone, these warrants do not provide an ongoing prohibition against such persons' possession or acquisition of firearms, and do not provide a basis for entering those persons into the National Instant Criminal Background Check System and corresponding state firearm background check systems as individuals prohibited from possessing firearms. Why? Because you have not committed a crime, nor have you been found guilty beyond a reasonable doubt. That's how you lose your rights in this country. It's because you're a criminal and they have proven that you have violated that crime. That's it, period, point blank. Okay? Now, the other version. The order statutes provide for ongoing prohibitions of firearm possession and acquisition, and a basis for entering dangerous individuals into the background check system as ineligible to possess firearms. Their main goal. However, their design may require a law enforcement officer to initially present the order to the dangerous person and ask him or her to surrender his or her firearms. If the person does not comply and the firearms are not in plain view during the encounter, a second step may be required in which the law enforcement officer goes back to court and secures a search warrant to look for and seize the subject's firearms. The delay may inadvertently give the subject advance notice and time to hide the firearms, or potentially time to use them to seriously injure or kill someone before the police can return with a search warrant. This model legislation combines both approaches. It includes language that would authorize the judicial issuance of no firearm orders for dangerous individuals and the concurrent issuance of search warrants to search and seize their firearms. Now, the rest of this, I'll put a link down below if you want to read it on your own, but the rest discusses the ex parte hearing. Now, ex parte is a hearing in secret done between the accusatory body and the judge. If you're the person that's the focus, you're not notified of it, nor can you have an opportunity to confront your accusers or defend yourself. You're not there. They do this behind your back in secrecy. And then the judge decides, you know what, let's go take this person's rights because this person says that they might be doing something bad. Now, I will say that many states have extreme risk protection order laws. And I know somebody's going to ask in the comments, so I'll put it out there now. Vermont, New York, Massachusetts, Connecticut, Rhode Island, New Jersey, Maryland, Delaware, Virginia, Florida, Illinois, Indiana, Washington, Oregon, California, Nevada, Hawaii, New Mexico, and Colorado. Now, some of the states call it something different. Some call it the Extreme Risk Protection Order. Some call it our Extreme Risk Prevention Order. Some call them Gun Violence Restraining Orders. It's all the same. But what's also key to note is that some states have varying requirements as far as the culpability. For instance, some states allow intimate partners to seek out an extreme risk protection order. Some states allow co-workers to do it. Some states allow healthcare providers to do it. And some even allow the school systems to do it. So you can see there's a little bit of wonkiness going on, but the key thing to remember, guys and gals, is that the red flag is the most unconstitutional, illegal threat to our right to keep and bear arms. Why? Because it's not done in criminal court. It's not a criminal violation. They're coming after you civilly. And what happens in a civil lawsuit, for those who aren't up to date on our Bill of Rights, in a civil lawsuit, you don't have the right to an attorney. Which means that if you want an attorney, it's on you. And if you show up to a red flag hearing and you don't have an attorney, there's an old saying, he who represents himself represents a fool, because they will eat you alive and you're going to lose your rights. Now, they might even do that if you have an attorney, depending on the quality of the attorney you bring. But the point is that you are not guaranteed your right to representation in this system, because it's a civil system. A civil violation, if you will, that looks to remove your guaranteed right to self-defense on a whim, on the word of another, not because you were found guilty by a court or by a jury of your peers beyond a reasonable doubt, but because they catch that judge and he goes, man, you know what? Okay, let's do it. Because nobody wants to be that judge who just says no, right? And then, God forbid, something does happen. But that minute chance that happens, everybody else is going to pay for it. It's ridiculous. It's disgusting. And I want it on your radar, because what's going to get this into the states that don't have it? Money. They're going to bribe the states. They're going to create ways for states to get paid for doing this. Trust me. Now, again, I'll put the link down below. You can look at it. It also talks about the hearing after the ex parte orders are issued. You get a chance to go before a court. It allows the state to make up how much time they allow you to do that. It could be 21 days before you get your chance before a judge, which means for 3 weeks, they've stripped you of your rights and your property. God forbid you need to protect yourselves, they have stripped you of that ability to do that. It also talks about the minimum amount of time that the people get their rights taken away from them, unless it's ended early by the court. But the minimum's 180 days, 6 months, and they also want a clause to be extended to a year, and then to obviously be renewed after that. But the key point is they want more people prohibited when it comes to firearms. Case in point, let's look at Section 4 of this model legislation. Now, Section 4 would provide for the prompt entry of orders issued under Section 3, and that's the orders after the court hearing, and also to have them entered into the national and state firearm background check systems that identify persons as prohibited from possessing firearms. And this is exactly what it says in the order. The court shall forward any order issued under Section 2 or 3 to an appropriate law enforcement agency on the day it is issued. Upon receipt of an order under Section 3, the law enforcement agency shall make the order available to the NICS system and any state system used to identify persons who are prohibited from possessing firearms. Guys and gals, I will stay up to date on this. I will keep you in the loop, and all you have to do is subscribe to Guns and Gadgets. Hit the little button down below. Join this growing freedom family. We are stronger with you as a member, because more people get to see the news. And I hope that you thumbs up the video and share it, because that greatly helps this channel. And until we see each other again, be safe, stay vigilant, carry a weapon. I'll see you on the next one. Take care, everybody.